Good day, everyone. Today I will be presenting Chapter 18, which centers on Republic Act number 10,175, more commonly known as the Cybercrime Prevention Act of 2012. This legislation signifies the Philippine government's comprehensive response to the emerging threats and challenges within the digital environment. In this discussion, we shall examine the rationale behind the enactment of the law, its key provisions, as well as its implications for digital rights and cybersecurity. Furthermore, we will explore its origins, its legal and societal impact, and the controversies it has generated since its passage. My name is Eliza Brocal, and it is my privilege to guide you through this significant and relevant topic. Let us begin with a bit of digital activism history. When the Cybercrime Prevention Act was passed in 2012, many Filipinos took to social media and protest. They turned their profile pictures black and used the hashtag No to Cybercrime Law to express their stand for internet freedom. This online protest quickly became one of the country's first large-scale digital movements. It raised two major concerns. First, the law's cyber libel provision was seen as a threat to freedom of expression, as it could criminalize ordinary online posts like satire, memes, and criticisms. Second, there were fears of government overreach since the law allowed access to user data and online content without clear judicial safeguards. Through their online actions, these netizens showed the power of digital unity in defending rights and calling attention to the need for a balance between the cybersecurity and online freedom. Why was there a need to enact the Cybercrime Prevention Act in the first place? As the world grew increasingly dependent on the internet, so did the risk, ranging from credit card theft to large-scale online fraud. One significant turning point was in the year 2000 when the I Love You virus, which originated in the Philippines, caused billions of dollars in damages worldwide. Incidents like this highlighted the urgent need for strong legal measures to protect users, uphold cybersecurity, and maintain public trust in digital systems. By the end of this presentation, you will be able to clearly understand what the Cybercrime Prevention Act of 2012 is, its objectives, and its role in addressing cyber-related offenses. You will also learn about the key factors that led to its enactment, including the rise of cyber threats and the need for digital security. In addition, you will gain insight into the major provisions of the law, such as cyber libel, hacking, and identity theft, and their implications for online activities. We will also examine its impact on digital rights, particularly concerning freedom of expression and privacy, as well as the challenges in its implementation and enforcement, and consider possible reforms to improve its effectiveness. Defining the Cybercrime Prevention Act of 2012, Republic Act number 10,175, is a wholesale statute intended to govern a range of digital crimes. It sets legal parameters in online behavior, it safeguards important digital infrastructure and sensitive data, and it sets up mechanism for cybercrime investigation and prosecution. In essence, it takes our criminal justice framework and shoves it into the internet era. And it lays out clear definitions and penalties for a wide range of what a would-be cybercriminal can do. There were five important factors contributing to the passage of this law. First, digital expansion, as more Filipinos and businesses move online, created an almost exponential surface on which cyber threat could impeach. Second, new cyber threats like new viruses, phishing schemes, and hacking techniques proved that there were few laws in place. Third, there came an increased awareness and need to protect personal and corporate information from misuse. Fourth, e-commerce and e-government services demanded a secure virtual space to preserve public trust. And finally, international trends revealed that the other countries were already enacting cybercrime legislation, and the Philippines were required to move in step to become credible in the global approach to digital governance. Major provision of the Act. The Act prefers to criminalize several separate crimes, each of them intended to target a particular menace. Cyber libel expands or defamation laws to internet contents and has promulgated free speech fears. Identify theft and fraud include the use of one's personal information, either for financial or reputational purposes. Hacking and unauthorized access penalize people who get into computer systems without authorization. Furthermore, the Act modernizes the long-standing criminal provisions such as copyright infringement or child pornography to incorporate their respective online versions, which will bring the same cohesive approach towards both cyber and physical courts. Impact on digital rights. Even though the law protects users, questions related to the preservation of fundamental rights arise as well. The cyber libel provisions can stifle online speech and contrariness because individuals and journalists can fear to put forth the critical content. With unbridled expansion of surveillance and data gathering powers, there comes a threat of passion for privacy. Besides, by creating legal traditions for the balance between security and freedom in cyberspace, the Act affects the long-term digital rights discussion and policymaking in the Philippines and elsewhere. The enforcement of a cybercrime law presents its own difficulties. High rate of technological change implies that there arise new threats which develop faster than laws are amended to cope with. Cybercrimes are often so transnational in nature that it becomes difficult to enjoy the cooperation among law enforcement bodies. Principally and specific legal language and generalized definition may result in the inconsistent use and incorrect usage. Legislation should be adaptive to handle these challenges, and successful enforcement should involve continuous partnership between technologies, civil society, champions, and industry players. Case study in 2020, Maria Ressa journalist and Rappler researcher Reynaldo Santos Jr. were convicted of committing cyber libel under this act for republishing an allegedly libelous comment from 2012. This high-profile case became the world flashpoint on how retroactive application and expansive libel provisions can bring press freedom on its knees and pose question marks around the standards of the fair trial in the digital world. In case of Ressa, courts confirmed that cyber libel could be applied to comments prior to the enacting of the act, causing fear of retroactivity. This precedent is a tortoise walk for many in the media community who fear it represses investigate, reporting, and critical commentary. Overseas, both human rights groups and foreign governments condemned the decision as a menace to media freedom, insisting that action that threatens democracy and self-censors. Some of the key challenges in enforcing the law, including finding the right balance between regulation and freedom of speech, and protecting individuals' reputations online without limiting public criticism or dissent. There are also concerns about retroactive application, whether it is fair to apply new laws to actions committed before the law existed. In addition, questions have been raised about whether unclear or vague terms in the law could lead to unfair or abusive enforcement. These concerns highlight the importance of clear legal definitions and strong safeguards in any law that deals with cybercrime. As we have seen, the actual difficulty is not merely writing laws, but constructing an online world that is both safe and respectful of those basic freedoms. Ongoing discussions between lawmakers, technologists, and civil society groups will be fundamental to getting this balance right and to ensure our digital future remains open, secure, and just. Thank you. May this presentation help us stay more informed and responsible as digital citizens.